docket, case number 109778, State of Kansas v. Davison.
Mr. Davison appears through counsel Michelle Davis. May I please request 5 minutes for rebuttal?
5 minutes is granted.
Thank you. We're here today on the district court's denial of Mr. Davison's motion to withdraw plea on procedural grounds. This is a case that Mr. Davison entered a plea to a charge of felony murder. Basically, the underlying facts were that in the commission of a robbery, aggravated robbery, that a man was killed, and that's the factual basis for the felony murder. And that happened in 2000. And then in April of 2009, the legislature amended the motion to withdraw plea statute to require that it be filed within 1 year of any kind of final order or judgment. So up until 2009, there had not been that time limitation. And so that 1 year time limit began to run then in 2009. Mr. Davison filed his motion to withdraw plea in 2011, so he was 1 year and 1 month out of time from the 1 year requirement. So what the district court did in this case is it had an evidentiary hearing regarding the untimely filing of the motion. So to withdraw his plea, Mr. Davison was required to show two things. He was required to show manifest injustice for the plea withdrawal. This was a case where he did receive a life sentence plus some consecutive terms, so he would be in prison for the rest of his life. And then also excusable neglect, and the district court proceeded only on the question of the excusable neglect. And the district court ruled that he had not shown excusable neglect. Mr. Davison's reasons, what he testified for not filing the motion earlier, was that he did not know. He did not know of the concept that you can move to withdraw a plea until he heard a couple of other inmates talking about it. And at that point, he pursued the motion. He got some help from another inmate and he filed his motion. The evidence was that he said there is a law library at the prison, but it's very hard to access. You can go in and ask for things, but I didn't even know what to ask for. I didn't even know the concept. So the question here, it's pretty clear that there's neglect. The question then is whether it's excusable neglect or not. And the district court did not really give us its reasons for not finding the neglect to be excusable. The court just said this wasn't excusable neglect. But we don't exactly know the district court's reasoning for that. I think the best argument for why this is excusable neglect is that this wasn't a situation where Mr. Davison was aware and he failed to act, or he was let the matter lay. I would argue that under the statute, this is a fairly new statute, there's not much law on what is excusable neglect. It's a phrase that's very common in civil statutes for why things may not be timely in the Code of Civil Procedure. And so I would argue that based on that case law, that this is an equitable determination. It needs to be made. This is not a substantive law, this is a procedural rule. And especially in the context of a criminal statute. And so it would be based on the circumstances.
So you're suggesting any time excusable neglect is a basis to is a basis that it warrants a hearing?
Well, in this case, the district court did grant an evidentiary hearing to Mr. Davison, and he did testify. So that's not really, I think the question here is the judge just didn't feel like what he offered was sufficient for the court.
Met the standard, whatever the standard was.
Right.
So this is the case to define the standard and to decide whether this meets it. Did the testimony reflect that he had ordered his materials for his case at some point? Wasn't that several years before he filed?
I think the state said that the record showed he had written a letter to the judge in 2008 asking for his pleadings. And there was something about he had written a letter about restitution. But I think that's it. So I agree that what's before this court is to define the standard. Again, I don't think other than it's an equitable concept and it has to be based on the circumstances. I think the cases that the state cites in its brief of a failure where there have been untimely, and whether that's excusable neglect, many of those cases it was where an attorney had failed to do something that they should have done. And there's only a few cases, I think, that the state cites where it's one of them is the defense that I didn't know I was supposed to register, but that's a substantive law. That's different here from a procedural. So the cases of the state cites are all where attorneys fail to do something. And I think you can hold attorneys to a higher standard than you can an inmate who's incarcerated who has no access to a lawyer and very limited access to even be able to do any research or anything like that. So I think there's a different standard here in terms of weighing all the relevant circumstances that you're dealing with in terms of ignorance of
Counsel,
the rules.
besides finding fault with the cases that have been cited by the state, what is your best case to support your position today?
That would be the case, the Pioneer case. It's 507 U.S. 380. It's cited in the state's brief. And in that case, it was a late filing in bankruptcy court. It's a civil case. But the United States Supreme Court talked about it being an elastic concept and an equitable determination, taking into account all relevant circumstances. And so I think at a minimum here, what we would ask the court to do is to consider remanding this case to the district court, to give the district court some kind of standard to apply. Because it's clear that the court just ruled there was an excusable neglect, but we don't know what factors that the court took into consideration other than the court's own subjective belief of what's excusable and not excusable.
In the civil
So-
context, it's required more than just a showing that someone was ignorant of a rule, hasn't it? In the civil context, for the 260 cases, for example, it's required more than that, hasn't it?
Well, yes, because again, those are attorneys, and it's presumed that ignorance of the law doesn't work well for attorneys to be arguing. And so I agree that that's a difficult, I think that needs, given that the legislature's provided for excusable neglect, that has to mean that in some cases, ignorance of a procedural rule or ignorance of a remedy has to be a circumstance to be factored into the equation.
We also, in the criminal law, have the concept that ignorance doesn't excuse. We're all presumed to know the law, and so even though this is procedural, doesn't that concept still apply here?
It does, but I think when it's a procedural rule, I don't think it should be as rigid as when you have a substantive law. So a lot of that case law
But
deals with a substantive law. So a defendant can't say, well, I didn't know, you can't, it's illegal to drive under the influence.
Even in substantive law, the U.S. Supreme Court has said law enforcement officers don't need to know the law, or not presumed. In the Hyman case, if there's a good faith ignorance of the law, then that excuses their actions.
That's true, that's true. And it, obviously, in this case, the legislature has provided, the legislature doesn't say it's illegal to drive under law, or to drive under the influence unless you don't know that. I'm sorry, it's illegal to drive under the influence unless the defendant can show excusable neglect. I mean, they don't say that with substantive laws. It's a different, so the fact that they've provided, I mean, that's what the Pioneer case says, is the fact that the legislature's provided for this equitable remedy. The district court needs to do some weighing. There need to be some factors to be considered.
Even if Mr. Davison didn't understand the procedural mechanism to bring his issue to the court, is there an excuse for him not bringing his disagreement or his sense that he'd been cheated, or that that plea shouldn't have been entered? I mean, if that's the heart of his issue. And so is that what we would look at to see if we can excuse his failure to do other things to pursue getting that before a court?
Yeah, and I think some of the factors that have been considered are, for example, his good faith. Is there evidence of good faith? And then the effect of the delay upon the parties, I mean, the reason for the delay, the effect of the delay. Those are things I think can be considered. Obviously, on a motion to withdraw plea, that can cut both ways, but the state obviously has an argument there, the prejudice to the state from an untimely motion. Of course, in this case, it's only a year, a little more than a year, so that might not necessarily help the
Well-
state, but those are some factors to be considered.
A little more than a year from the deadline,
Right,
but it's actually a 2000 case.
right, but I think we have to go from the deadline because,
Well, not if you're looking at prejudice in a particular case. If you're gonna do case by case,
yeah.
then you have to allow that to be considered, don't you?
Well,
That if you withdraw the plea, that means you go back and try the case.
yeah,
And if you're looking at witnesses from 15 years ago rather than 1 year ago, trying to round them up, it does make a difference.
well, yes, and I don't think that's gonna come up too much now that we have all these cases, it's gonna be 1 year. I don't see too many cases going back this far, but,
You're
yeah,
asking for an
obviously.
exception from that, though.
Well,
And then you have to look at the lag time between the conviction and the time the motion's filed.
Right, and so this is the circumstances, the kind of factors that a court can consider. Just the other thing is, I mean, the defendant still has to show manifest injustice. I mean, there is the law does tend to say we don't like default type of remedies, procedural default remedies. We do favor hearing cases on the merits. And so that would be the other reason to interpret excusable neglect fairly liberally.
Well, do you have an excusable neglect as to why he didn't attack his plea that was entered in November of 2000? Take the deadline off the table. Just what excuses him waiting all this time to attack the plea?
Just his testimony that he was not aware that there was such a thing as moving to withdraw a plea. And the record does support that because at the plea hearing and in the plea advisory, they're told when you enter a plea, you're giving up all of your rights. You're giving up all your rights to challenge your conviction. So the belief that that's it, there's finality, there's no remedy, there is support for that, for his belief. That concludes my comments.
One question I have. What's our standard of review of this decision by the district court?
Well, the standard of review on a motion to withdraw a plea is an abuse of discretion.
And then, so my follow-up is, clarify for me, because I'm having trouble telling whether you're arguing under our three ways that discretion can be abused, whether you're arguing that no reasonable person could have found excusable neglect here, or you're arguing that the district court made an error of law, essentially applied the wrong legal standard.
Well, I think my argument would be that it's not clear what standard the court applied because it didn't explain that to us. And the basis for asking for a remand would be that the district court have to apply some kind of standard set forth.
So under our standard of review, your argument proceeds under that second ground, that the judgment was based on an error of law, not that no reasonable person could find what the district court found here.
Well, we can't even say an error of law because we don't know what
Okay.
standard the court applied.
And you really need that standard before you can look at the third way to abuse your discretion, whether sufficient facts supported that. We can't know what facts are necessary till we know the standard, right?
That's right.
Yeah.
Thank you.
Was your client represented by counsel at this evidentiary hearing?
Yes. Yes.
All right, thank you. Any further questions? Thank you, counsel.
May it please the court, Linus Thusta for Neosho County in the state of Kansas. This case is one that really is, to me, fairly simple. The statute, which is KSA 2232-10E1, is pretty specific. If you want to file a motion to withdraw a plea or really file a post-sentencing motion, it has to be filed within a year. That is the standard. However, there is an exception that if there is excusable neglect, the court can consider it. However, that is an affirmative requirement on the moving party to show that there was excusable neglect. Now, when this case was presented at the trial level on the motion to withdraw the plea, the court listened to the testimony. And if you listen to or review the record, you'll discover that in the motion that the appellant had argued his excusable neglect was he didn't have access to the law library, he wasn't wise to the law, didn't understand those things. But then when he got on the stand and testified, he actually factually said, well, yeah, I did have access to the law library. I actually did know who to ask to pull things from the law library if I needed it. So his sole basis of claiming there was excusable neglect, he, when it was put on the record to testify, could give no reason, because his basis in his motion, he acknowledged during cross-examination, he had access to all of those things. So the
Counsel, let me interrupt here. Your opposing counsel said that part of the reason why so much time went by is that the defendant didn't even know you could collaterally attack your plea by moving to withdraw that. Is that something that was said during the hearing?
Not
that
really.
He said, not really, or not?
I did this hearing, and I've reviewed the transcript, and I don't remember that being brought up. But what I do remember was when he was initially given, when he entered the plea in 2000, because I also was the prosecutor who did it, he was informed during that hearing, and I believe the plea petition is part of the record, in which it describes the ability to withdraw a plea. So he would have had the knowledge in November of 2000 that there was an existence of something to withdraw a plea. That's pretty standard, especially when you're in a smaller jurisdiction, what the court goes through on when taking a felony plea, especially in a place where a murder would have been one of the few murders that have happened, I will tell you, in my lifetime, since my hometown.
Is the transcript of the plea hearing in the record
I
on
believe it
this
is
case?
part of the record.
Okay, thanks.
This was not an easy case. To show you the complexity and knowledge of the appellant in this case, it wasn't his first go around with the law. In our brief, we cite the things that went on. In his petition to withdraw his plea, he talks about his attorney at the time telling the court why he was guilty and not know the reasons why he was innocent. His knowledge of the roughly 13 motions that we filed and giving him every opportunity of knowing what he could do, they tried some stunts. This was a case that was filed originally as a first-degree murder case in which the hard 40 was going to be sought, and then the alternative was pled to felony murder. But before it was pled, his knowledge and this is part of the record, was to come forward and attempt to enter a plea of guilty to the felony murder and then argue double jeopardy to get rid of the underlying original murder charge. It's not like this was not a non-sophisticated person who would have ignorance. He had great knowledge of the law as far as back as 2000 and in 1999 when he was originally charged. So his ignorance of fact, I understand the cases that we cite deal with lawyers, but this great state and this great court has said at least since the 1800s, since 1882, that ignorance of the law is not excusable neglect, or it's not an excuse. So if it can't be an excuse, how could it be excusable neglect? He had the knowledge, he had the understanding. And further, in addition to the court following the statute, which prohibits anything after a year unless there's excusable neglect, I think you would be required by the law to determine if this is an abuse of discretion, and to say that no other judge or no reasonable judge would have looked at this and said, after hearing that you did have access to the law library, reviewing the file and seeing in 2007 they had sent a letter to then Judge Brazel asking about his restitution because he wanted to review it, In September of 2008, sent a letter requesting copies of all of his pleadings so he could review that. And then another 3 years pass before he files his motion to withdraw a plea claiming excusable neglect. He had the knowledge before the statute was passed. There's no explanation of why a decade had passed and more before he filed anything. There was never any testimony they put on that he tried to contact his former trial counsel, who was the public defender and would have been in place during this entire time period, that he never tried to contact anyone to ask them, what can I do? Well, when you're sitting in prison, I'm pretty certain you'd have plenty of time to do things, to think about legal arguments. Just look at the pro se arguments that we receive all the time. But he took advantage of none of those things. And I don't think when the court follows what the statute says by saying you're just out of time and have not presented excusable neglect, I don't think that this court should require a trial court, when it's clear on its face, to give an explanation of why this isn't excusable neglect.
Can you define excusable neglect as you're using it?
Excuse me?
Can you define excusable neglect as you're using it? What is the standard that you're using?
Well, my standard would be that it has to be something that would be, I would say, extraordinary. Not something that's run of the mill, like I didn't realize I could do this. To me, it would be something, say the law had changed at that time and they didn't know that the law had changed and it was something that would benefit them. I would say excusable neglect would be if you were hospitalized and were in a coma for 10 years and then awakened, that would be excusable neglect because you were out of the ability to control what's going on. Here, he still had that control and ability to file a motion, but he chose not to.
Didn't we have a change in the law in 2009? If we hadn't had the 2009 statute, then we wouldn't be talking about this. He could have filed his motion to withdraw a plea at any time.
And I would indicate, as was one of the justices asked earlier, Justice Johnson, was if that deadline's not there, which he would have had a year after the effective date of that to file. But if it's not there, he still at least has to show a claim of manifest injustice to even get it heard. And he didn't even make a prima facie showing of that in his motion. So whether you even look at the time limit that's put in place by statute, even in his motion on its face, there is not really any argument to show there's manifest injustice. Because again, his knowledge of the situation, he understood what was going on. The judge took painstaking time in taking the plea to make sure he understood that. But then to come in later on and say it's manifest injustice because I didn't know I could file a motion to withdraw my plea, that's like saying I didn't know I could file a motion for discovery after the fact. You have that information up front. The court has specifically asked him questions if he understood this is your chance and this is what you can or cannot do when you enter a plea. I would put this akin to someone trying to come in a decade after the fact and saying, I didn't know I could appeal the sentencing.
But doesn't manifest injustice deal more with the actual merits of the plea withdrawal rather than procedurally? And your argument in that regard here would be that he pled to felony murder to avoid a hard 40 on the first degree premeditated, and so he got a good deal, so it wouldn't be manifestly unjust to refuse him to withdraw that plea. But that's different than saying that procedurally he's barred and doesn't get his day in court.
Well, I view this very similar as basically a 1507, which the court has the authority, if on its face they don't state a prima facie case, the court can summarily deny that. In this case, if the court reviewed his petition withdrawal plea and could see on its pleading and on its face, there is not sufficient evidence or not sufficient argument to justify manifest injustice, I don't think you even have to get into the merits of which your argument, yes, Justice Johnson, would be correct.
So in other words, you're saying that we can affirm the district court for a different reason?
Yes, you could
That
affirm
there
it.
was no merits to the motion regardless of its timeliness?
That would be.
Were the
correct.
merits ever addressed of the motion at the hearing, or was it just the excusable neglect aspect
There was some argument about the merits.
about the manifest injustice?
About the manifest injustice. However, the court did not really address that, and we bifurcated the hearing to make sure, Your Honor, that we would argue first, is this an issue of procedure, but we'll also put some of evidence on, because if the court denies it based on the statute of limitations, the court wouldn't necessarily have to take up the merits, but we also put on argument regarding the merits, so the court wouldn't have to take two things. So the court merely made the decision that this was not procedurally there because the 1 year statute of limitations had passed, which I think if you were in front of most trial judges, they would have made a similar decision, because it's over a year old and you have to have something more than I didn't know what the law was to say that's manifest injustice, or to say that that's excusable neglect.
Opposing counsel, I believe, made the argument that the particular type of abuse of discretion that she was relying upon to say that the district court erred was the court made an error of law because he did not follow a standard when he denied the motion. If I understood her argument correctly, assuming I did, can you respond to that?
Well, I would say that standard that's what's in the statute. Is there excusable neglect? And I think that's basically left to the discretion of the court as to what is excusable neglect. And then the standard for abuse of discretion is this something that's fanciful? Is this something that was arbitrarily decided? Is this something that no reasonable judge would have decided? If the court would have just said, you've been in jail, I don't care what you say, it's denied, that would probably be pretty clear, something that would be abusing the standard of, is this excusable neglect? But he took the time to address whether or not this was excusable neglect in his order, and goes through the facts of what he argued, and then specifically says, but this time is just too late and you have not presented things. The other part of that in response would be, the statute makes it an affirmative duty on the court, on the appellant in this case, to argue there is excusable neglect. The court could have simply said, you didn't meet your burden of showing this was excusable neglect, and that would have been sufficient. But he went further and gave a basis for that decision. And so it's pretty clear in multiple cases, the court, if you think this was a fact-finding issue, if this was in front of a jury, we don't ask a jury to come back and give an explanation for the facts and basis of what they made their decision. We just asked them for a decision. In this case, if the court said, the facts you presented are not sufficient to show neglect, excusable neglect, the standard is there in statute. To say it has to be a bright line test is something that this court has not done, and in quite a few areas has shied away from bright line tests.
So a statement, this is the standard, excusable neglect, and a statement that the facts you presented, Mr. Defendant, did not meet that standard is sufficient.
That would be my belief, because again, if you look at 1507, the court can summarily just look at it on its face and say it's not there. It's basically a failure to state a claim that is within the discretion of that court. And so the statute already puts that in place. Otherwise, why put the 1 year statute in there otherwise? That would mean then every single case that comes forward, the court would have to have a hearing to say, well, your argument is they didn't let me go to the bathroom, so that's your excusable neglect. We would have to have a hearing. The court would have to take the time to do it when it's something that is so clear on its face, does not get past that standard. And again, that's for an exception. We should be following the rule by law and should follow rules of law, not just follow it by the exception, because that's what is really here. This is supposed to be an extraordinary remedy.
counsel has earlier in her argument indicated that excusable neglect, according to the U.S. Supreme Court, is a flexible concept and it's based on equity. Given that, does that change your answer?
I would still say based on equity, I understand what the Supreme Court has said, and I also understand the Supreme Court has also upheld the standard largely in spite of the case that the court described earlier, that ignorance of law or ignorance is not an excuse. But I would say in equity, when you attempt to get out of the bargain that you've already entered into, as opposed to some hardline test, the court had the ability to look and see in equity, what did you get from the benefit of your bargain? And now to come in later and have buyer's remorse, which is essentially what this is, or look for a trip to get out of prison, is not something that we're going to do. In equity, he could still look at what was filed and make the determination there was not excusable neglect and the statute with limits of 1 year would still be in place.
Very good, thank you.
Thank you, Your Honor.
Do we have any more questions of counsel? Any further presentation? Thank you. You reserve 5 minutes for rebuttal.
Thank you. Just briefly, the district court in this case was prepared, came to the hearing to address manifest injustice. The problem was that the transcript of the plea hearing and the sentencing hearing had not been prepared. So the court could not do that. So the court said, well, let's go ahead and take up excusable neglect then. And that's why the process got flipped in this case. So that's all the district court addressed. And then the transcript of the plea hearing is in the record. It's volume 16. I read the record again. I don't see where Mr. Davison was told that if he could come back later and move to withdraw his plea if he wanted to.
Yeah, I don't remember that being a part of the plea colloquy, that you can file a motion within a year or at any time that you can file a motion to withdraw this. I don't remember that.
Yeah, that's pretty unusual. I don't think I've ever seen that. So
I understood him to say it was in the plea agreement. Was there a
in the
written
plea
agreement?
advisory?
No, was there a written plea agreement?
Okay,
in
I
this
didn't
case?
take a look at that because I thought he said it was at the hearing, but
I may have misunderstood, but I thought he said it was in the plea agreement.
okay. So, and I didn't look at that, so
Okay.
you have to take a look at it yourself. But anyway.
Were there any objections by defense counsel to the journal entry that was prepared that established the conclusion of law and the findings that the court made?
No, I don't believe so.
Very good. Any further presentation?
No, thank you.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.